Now we begin our discussion of agency relationships in Virginia. This is probably the most important section in this Virginia study guide, so you will want to pay close attention to this information. We'll discuss some important definitions, obligations to clients and customers, different types of brokerage relationships, disclosure of brokerage relationships, dual agency, designated agency, and limited service representation. We begin our discussions of definitions with two of the most important terms, agency and brokerage agreements. The term agency means a relationship where a real estate licensee represents a person in a real estate transaction. This can be done as either a standard agent or a limited service agent. We'll discuss the obligations of a standard agent momentarily, and we'll show you all of the obligations a standard agent has towards a client. We'll also show you that a limited service agent has an agreement with a client to waive one or more of the obligations of a standard agent. We should note that the contract might call for additional obligations over and above those contained in the Virginia laws and regulations. A brokerage agreement is the contract that creates the agency relationship between the licensee and the client. It might be an agency relationship or a non-agency relationship, and we'll define those terms shortly. A brokerage relationship means the contractual agreement between the client and the real estate licensee that establishes the formal relationship. It could be either an agency relationship or a non-agency relationship. It will spell out the duties, functions, and obligations of each of the parties. The term client refers to a consumer who has signed a brokerage agreement with the licensee. A common source information company is a person or firm that compiles information about real estate for sale or lease. The classic example of this would be the MLS, but Zillow.com, Trulia.com, and Realtor.com are all websites that do this as well. A customer is someone who has not entered into a brokerage relationship with a licensee. When working with consumers as customers, a licensee may only provide ministerial acts, which we'll define shortly, but basically that means that the licensee can help with the paperwork but cannot provide advice to the consumer. A designated agent is a salesperson or associate broker who represents one side of the transaction in an in-house sale, where the firm has a brokerage relationship with both the buyer and the seller. As we'll discuss later, the broker assigns this licensee to represent only one of the parties in the transaction. It's used in lieu of dual agency. As you are no doubt aware, a dual agent is a licensee who acts as agent for both the buyer and the seller in the same transaction. It could also refer to a licensee who acts as agent for both the landlord and tenant in the same lease transaction. Now we come to the term independent contractor. Most real estate agents are independent contractors for tax purposes, but that's not what this term means in the Virginia law of agency. In agency law, the term independent contractor means a licensee who has entered into a brokerage relationship where the licensee will not act as agent of the client and will not undertake all of the obligations of a standard agent. Instead, the independent contractor will only undertake those functions and obligations that are specified in the brokerage agreement. An example of an independent contractor might be a discount real estate brokerage firm. They will provide a seller with for sale signs and real estate contracts and will put the listing on the MLS, but will not conduct any marketing efforts for the seller. The seller markets the property personally. The seller pays a much smaller commission to these discount firms. The discount real estate brokerage does not act as agent for the seller in this transaction. A limited service representative is a licensee who represents a client regarding a 1 to 4 unit residential property and has a brokerage agreement with the client, but this agreement states that the licensee will not undertake all of the obligations of a standard agent. Instead, it specifies what the obligations of a standard agent are and which of those standard obligations the licensee will not undertake. If the licensee will serve as agent of the client, that must be clearly stated in the brokerage agreement, otherwise the licensee will be deemed to be acting as an independent contractor. These final three definitions are fairly straightforward. Ministerial acts are routine acts that a licensee can perform for a consumer that do not involve discretion or judgment and do not require a real estate license to perform. They tend to be clerical functions, but there are others as well. The property management agreement is the agreement between a property manager and a property owner governing how the property will be managed. As you might expect, a standard agent is an agent who undertakes all of the obligations of a standard agent under Virginia law. We'll define these standard obligations next. Before we list the obligations of a standard agent, we need to deal with the issue of false information. Of course, licensees are not supposed to give false information to clients or customers. However, if the information was received from a client, the public records, or another regulated professional, such as an attorney or accountant, then the licensee is not normally liable for passing on the false information, unless the licensee knew or should have known that the information was false. We've mentioned the standard obligations of an agent to a client several times already, so now let's take a look at what they are. The first obligation is to perform according to the terms of the brokerage agreement which establish the agency relationship. The first of these is to seek the price and terms which were agreed to in the contract. Also, the agent must disclose all material facts about both the property and the transaction. Notice that it's not just the adverse material facts, but all material facts. It also includes the obligation to reveal material facts about the transaction itself. As we mentioned in Chapter 5, this goes beyond the duties to customers. Standard agents are obligated to present all written offers and counteroffers even after the client has already accepted another contract. This does not mean that they must continue actively marketing the property, but if an offer comes in, it must be presented. Naturally, you would need to make clear to both parties that this could only be a backup offer in case the existing contract fails to close. Otherwise, the seller is put in the position of having sold the same house twice. Licensees must also provide an accurate accounting of all money and property received in which the client has or may have an interest. This would include good faith deposits, for instance. Another obligation is to maintain the confidentiality of all personal and financial information of the client, as long as doing so does not violate the law. If you're representing a seller, for instance, you must not reveal that the seller might accept a lower price, but you would have to reveal any known material adverse facts about the property to the buyer, even if the seller asks you not to do so. There are 3 more standard obligations. Agents must exercise ordinary care. There is no legal definition of this term. If a client feels that the licensee did not do a good job of marketing a property, it would be up to a court to determine whether this standard was met. The licensee is not required to be the most effective marketer in the area, just to do what a reasonable real estate licensee would do under the circumstances. Licensees are required to comply with fair housing laws and other laws and regulations. If a client gives an unlawful instruction, the licensee is required to inform the client that the instruction is contrary to law and the licensee cannot comply with that instruction. The final point is that the law states that the agent does not breach his or her obligation to a particular client by providing essentially the same services for similar properties or clients in the area. Without this provision, a licensee could theoretically be limited to one listing at a time. Licensees do not have the same obligations to customers as they do towards clients, but that's not to say they have no obligations. The key rule is that they must treat customers honestly and fairly and must not knowingly give them any false information. There are disclosure requirements towards customers. Specifically, they must disclose all material adverse facts about the physical condition of the property which are actually known by the licensee. If a client gives false information to an agent and the agent passes that information along to a customer, the licensee would not be liable for that false statement as long as the licensee did not have actual knowledge of the falsehood and did not act in reckless disregard of the truth. For example, If the seller told the agent that the roof did not leak and there was no obvious signs of a leaky roof, the agent would not be liable to the customer if that turned out not to be the case. However, if there are clear signs of recent water damage inside the house that any reasonable real estate salesperson should have been able to recognize, the licensee would be at risk if he or she told the customer that the roof did not leak. We have defined ministerial acts to be acts such as clerical functions or placing for sale signs on a property which do not require a real estate license. Licensees may perform ministerial acts for customers unless prohibited by law or contract, and doing so does not create a brokerage relationship with that customer. There are only three permissible types of brokerage relationships in Virginia. The standard agreement is most common and obligates the licensee to undertake all of the obligations of a standard agent, which we discussed earlier, plus any extra obligations that are added to the brokerage agreement. A limited service representative has an arrangement whereby the brokerage agreement specifies which standard obligations will not be undertaken by the licensee. The licensee may act as agent of the client, but only if that fact is stated in the brokerage agreement. An independent contractor relationship means that the licensee is not acting as agent of the client and will undertake only those obligations specified in the brokerage agreement. Prior to signing a brokerage agreement, the licensee must inform the prospective client about the type of brokerage relationship proposed, how the broker will be compensated, and whether the broker can share that compensation. In Section 4 of this study guide, we mentioned that failing to include a termination date in a listing is an example of improper dealing. If a licensee does that, the licensee can be disciplined. The listing is not invalid, however. Instead, the listing will terminate 90 days after the listing started. Also, Virginia regulations state that once a purchase contract is fully executed, meaning that the transaction has closed, copies of all disclosures given to consumers must be kept for 3 years in either paper or electronic format. Licensees need to be careful when dealing with consumers with whom they do not have a brokerage relationship. Suppose you're holding an open house and a person walks in and looks around and then starts asking questions. At that point, you'll want to ask that person whether he or she is represented by a real estate licensee. If the person is not, you must disclose to this person that you're representing the seller in this transaction. You must do so in writing at the earliest practical time, but no later than when specific real estate assistance is first provided. Similar rules apply when leasing property. You must always disclose in writing who you represent, no later than in the application or the lease itself, whichever comes first. One of the best problems to have in real estate is to have an in-house sale, where the firm represents both the buyer and the seller in the same transaction, and therefore does not have to share the commission with another firm. The problem with in-house sales is that if you don't take appropriate actions, the firm can be subject to a lawsuit and disciplinary action by the board. That would happen if the firm does not take steps to avoid an undisclosed dual agency situation where the two parties are not aware that you are representing both parties in the transaction. One way to handle an in-house sale is through a legal dual agency. Dual agency is only legal if there is the written disclosure and consent of both the buyer and the seller, or the lessee and lessor in a lease transaction. In essence, the firm asks both parties to sign a form giving their consent to the fact that the firm will represent both parties in the transaction and must remain neutral between the two parties. They must respect the confidentiality of both clients. If either party refuses to consent to the dual agency, that party has the right to terminate the broker's agreement and seek representation from another firm. Another way to handle an in-house sale is through designated agency. This works especially well when one salesperson for the firm got the listing from the seller and another salesperson for the firm got the buyer's listing. The broker could appoint the listing salesperson as designated agent for the seller and the buyer's agent as agent for the buyer. The broker would be a dual agent, but each salesperson would represent only his or her original client. Each of them would continue to have the same obligations to their client that they did before the designated agency was created. Each client must receive a written disclosure of the change and must sign a written consent if they agree to the arrangement. Each designated agent can only represent his or her client and must not disclose any personal, financial, or confidential information to anyone other than the supervising broker. As we have said, a limited service representative chooses not to undertake one or more of the obligations of a standard agent when representing a client. Virginia law requires that the brokerage agreement disclose the status as limited representative, which obligations of a standard agent the licensee will undertake, and which obligations the licensee will not undertake. These disclosures must be printed in bold or all caps and must be essentially equivalent to the bottom paragraph on your screen.